Well, good morning, everyone, and thank you for joining us on this early morning for our first business breakfast here at Aitken Partners. The topic today is businesses rate, disputes, insolvency, and director risk in financial receives. My name is Nicole. I'm a principal lawyer here at Aitken Partners and head of the Litigation and Insolvency department. Now it's my pleasure to introduce our panel. So Alex Nicol. Alex is our managing principal at Aitken Partners, specialising in the insolvency, commercial disputes, and he regularly acts for insolvency practitioners, secured and unsecured creditors, directors and shareholders in complex administrations, receiverships and liquidations. Then we have Sam Merrylees, also from Aitken Partners, a senior associate and valued member of our team. He also is part of the intellectual property team. He has a broad practice in insolvency and commercial litigation, acting for insolvency practitioners, businesses, company directors, in a wide range of complex matters. We also have Jason Stone. Jason is a partner at PKF and is a registered liquidator. He has more than 2 decades of experience in insolvency and business turnaround. Jason is highly regarded advisor to businesses and operators and company directors, navigating complex and often high-pressure situations. Since specialising in corporate and personal insolvency in 2002, he's developed deep expertise across managing companies in distress, forensic accounting, business valuations, and both forwarding and informal restructuring engagements. Alex, Sam, and Jason were also recently involved in a very significant and successful case in the Supreme Court, which they acted for an individual who was defending claims by a liquidator for insolvent trading, some unfair preferences, and avoidable transaction claims. Please join me in warmly welcoming Papa. Now, a bit of an overview of what we're covering today. We'll first cover setting the scene, what's going on in the market at the moment. We'll then look at options, restructuring options that are available. Then thirdly, business disputes, director risks, some liabilities in this insolvency and restructuring context. As to questions, we hope to have some time at the end. But feel free, people online and in person, to ask questions throughout. People here, give me a wave. Online, feel free to enter your questions in the Q&A function that I understand is there, and we will respond to them as we can. So, first up, setting the scene and exploring the current climate and warning signs. Moving first to Jason. Jason, as an insolvency practitioner, what are you seeing in the market at the moment?
Thanks, Nicole. The market at the moment has seen significant distress and a lot of cleaning house following the effects of COVID. Insolvencies reached an all-time high last financial year, where they were double the level of insolvencies in 2020 and triple the level of insolvencies from 2021. The current financial year is projected to be slightly lower, but I think we'll continue to see insolvencies at a relatively high level for the foreseeable future. In terms of the market, whilst construction and hospitality continue to make up the large percentage of insolvencies. Construction is typically at least 25%, and hospitality is at least 15%. What we have seen is significant jumps in other areas, particularly transport, manufacturing, and retail, that all have nearly doubled in the number of insolvencies in the past 2 years. particularly transport. We're seeing a lot of distress in that space, and then that has a domino effect in terms of manufacturers and suppliers to that industry.
And Alex and Sir, from a legal perspective, what do you see?
Yeah, I suppose very similar to what Jason's just said. Certainly an increase anecdotally. I don't have the stats that Jason had to back that up, but from our perspective, probably from about 12 months ago, there's certainly been an uptick in inquiries from companies and company directors feeling a pinch from either the ATO taking a more aggressive approach or just the cost of money or their own business weighing. Certainly focused on hospitality in particular, construction and related industries, but certainly just seeing a real uptick in that area. I suppose flipping onto the dispute side, again, because money is tight, we get more inquiries about people trying to recover money, whether it's for a contractual breach or perhaps shareholder disputes. When money's tight, obviously the tension between owners becomes a little bit more exaggerated. So we certainly give more advice about those sorts of claims in times like this. Whether people are willing to spend money on lawyers to actually follow those through to conclusion is probably a bit of a debate, but we can all talk a bit more about that later on.
And yeah, obviously saying the same thing as Alex. The only other thing I'd sort of like to add to that is seeing a lot more personal insolvency approaches as well. And I think that's mainly driven or largely driven by the ATO as well. People going to pitch in that regard.
So we've heard a bit about the ATO. And Jason, what do you see as the role of the ATO in all this, and what's their current approach? And how do you see as different from what we have seen in previous years, particularly around the COVID period?
The ATO's enforcement has increased exponentially. It was basically at zero during COVID. The 21 financial year, they shut up shop completely, and in the next 4 financial years, they've gone from 0 to 200. We're seeing that the highest levels of enforcement from the ATO ever. They issued 84,000 director penalty notices last financial year. That was a 3-time jump from the previous financial year. They only issued 79 director penalty notices in 2021. So it's a huge jump. And director penalty notices are just one of their enforcement categories. They also going down the garnishee notice path in high numbers as well. They're sending out a ridiculous amount of warning letters. They're also able to make a note on your credit record, on your company's credit record these days. If your debt is greater than $100,000 and more than 3 months overdue, they can make a note on your credit record. They've also increased their enforcement on the side of that as well. So the wind-ups and bankruptcy notices that were initiated by the ATO were non-existent during COVID. I think in the 21 financial year, there was 3 company wind-ups and 6 bankruptcy notices initiated by the ATO. I don't have figures on what that is now, but the ATO is certainly flooding the courts with their proceedings at the moment. On the other side as well, in terms of payment arrangements, it is very, very difficult to get a payment arrangement up with the ATO these days. You are unlikely to get a interest remission as well. They will not budge with any of that. They want a significant amount up front, and then they want the balance paid over a short period of time, typically 12 months. If you're lucky, you might get 2 years.
Yeah, just a hiccup on that, I suppose, that certainly we've seen from 2 years ago where you could get a payment plan that was comfortably that 2-year period, probably nothing up front or a nominal amount up front. They certainly are, the starting point is at least half of the debt up front. they're not willing to waive any interest and probably pretty unwilling to waive penalties. The exception to that, I suppose, is some sort of formal insolvency process, whether it's SBR or voluntary administration. That's the only way you get any sort of compromise. And obviously that's in part forced on the tax office wiped into the regime.
In Alex, Sam, what are you seeing as some of the impacts of the APO's more aggressive enforcement activity?
Yeah, I think Jason sort of already touched on that a bit, seeing a lot more DPNs being issued. So the ATO's enforcement isn't only going to companies' debts, they're taking active steps to pursue directors for their liability for debts personally, the issuing of DPNs. We're seeing probably a lot of directors burying their heads in the sand when they're issued with DPNs and not being perhaps proactive enough and working with their accountant to understand what that means and how they can deal with that. So, yeah, seeing a lot more enforcement in the courts, chasing personal debts by the DPNs.
Yes, Rick.
Just for the kids at home, is it worth just really quickly explaining the director's penalty notice is?
I hope you wouldn't ask that, Rip.
Did you only read it in there?
Thanks, man. Maybe Alex.
Well, he actually told me what DVN stood for.
The question was, what is a director's penalty notice? Essentially, it's a notice the ATO can give to a director whereby the director is, if he doesn't comply or follow one of the steps, is going to be held personally liable for a debt of the company, and it covers a whole range of different taxes that the ATO can impose on a company, and it is a very strict 21-day time frame.
And probably the key distinction there is whether it's a lockdown or a non-lockdown DPN. So if it's a non-lockdown DPN, you have the 21 days to do something about it. Whereas if it's a lockdown DPN, your lodgements aren't up to date and the liability kicks in.
Yeah, a key difference is the ATO trying to encourage people to lodge even if you can't pay. And if you don't lodge, then they become lockdown DPNs, and there's a much more limited set of circumstances that you can take advantage of.
And probably the only thing I'll add there is superannuation is one of the liabilities that you can receive a director penalty notice for, and it's very difficult to lodge in respect to superannuation because you would have to do a superannuation guarantee charge lodgement, which directors don't typically do, which means that any DPN in respect to super is likely going to be a lockdown big.
On the ground, we're also seeing every week in terms of inquiries, many minimal new inquiries or in relation to wind-ups. So we've been talking about wind-up Wednesday in the Supreme Court. And almost without a doubt, Tuesday morning, we'll get new inquiries about wind-ups, and 9 times out of 10 it's the ATL on their side. And unfortunately, they're coming to us but late. Right? They've had a couple of adjournments, and you talk about limited options. We'll talk about that further down the track. That's definitely the experience now we've seen, unfortunately. In terms of the ATO, and Jason talked about the increased enforcement, we see it really triple. An interesting fact that I found on Aaron Felix was the tax ombudsman is now undertaking this year a review of the ATO's issuing of DPNs, given the huge uptick. So they're conducting a review into the decision, what they're going through, their processes when choosing to issue them. They're also looking at the effectiveness in relation to recovering for superannuation and employees, this sort of public focus. In case selection, communications with directors, around what they understand. And obviously for the ombudsman, our focus is on coercive directorships, and that's something we do see sometimes. This situation of certain members of family or friends that become directors and then down the track get DTAs. So we've talked a bit about the impact. Now let's move to the options. But we touched upon timing, and I guess that's the first thing I'd like to ask Jason about. Jason, in your view, when should directors come and see you to consider their options? And what advice do you have for directors who are, seeing the early warning signs of financial difficulty?
Look, by the time most directors get to me, it's quite often too late. They certainly have a habit of burying their head in the sand. So my response to that would be as soon as possible. There's absolutely no harm in having a discussion. And if you do identify some warning signs like trading losses, cash flow issues, creditors drawing out past their terms, the ATO and other statutory bodies' liabilities drawing out, and maybe perhaps an inability to pay financiers, then they're sort of highlights to consider and to look to have a discussion around what the options are to deal with it.
Alex and Sam, anything to add?
I suppose just to reiterate what Jason said, the sooner the better. Obviously we have slightly different focuses on these sorts of problems, but people are still definitely head in the sand and delay, and all that does is limit the options you have about how either we or someone like Jason can advise you through that process. So sooner the better, you'll only improve your options and therefore your out ones if you come to see us or an expert in the area soon.
And Sam, are there some early things you can do in terms of prior to seeing these difficulties?
Yeah, that was sort of what I was going to add on there is not only when there's signs of distress, taking advice at the earliest time possible, it's also when you're entering commercial agreements, understanding what you're doing, not just sort of signing up to it and then dealing with the implications when things go wrong. Actually sort of seeking advice and understanding what the company, if you're a director, what the company is entering into and your obligations under that. It's quite up to saying personal guarantees being an issue and companies go into liquidation and directors that becoming liable for that debt.
We actually had one recently, which is a bit of a sad story. He came to us with some advice, and one of the questions that we always ask is, have you personally guaranteed anything that the company is up for? And the answer was no. And we said, well, let's do a review of your principal contracts. Turned out that, unbeknownst to him, he actually had at least 9, probably more, personal guarantees that he'd signed, either in an agreement that he signed with a supplier or something like that. So obviously that very much changes the advice we give and the options that someone has available. So be very conscious of the terms of the contracts that you're signing as a director of the company.
What are some of these big contracts that some see these personal guarantees in?
Can be anti-expired agreements, trade terms, all those sorts of things that pretty much every company out there signs.
Leases is one of the new ones that people sort of desperate at the time. They think they really need to get into the property. So yeah, I'm going to sign it. But huge implications on the other end. Alex, what often is the root cause under distress, and how should directors approach potential litigation with limited cash flow?
I suppose the first aspect, I don't think there is any one root cause you can identify. That's very much an individual circumstance within the company. We've already touched on the ATO being a significant driver. The idea that the bank of the ATO can be strung along for a long time is probably a thing of the past now. Or if you do try and do that, you're going to face some stern repercussions. And how should directors approach, I suppose, litigation at that time? And obviously, independently of assessing your own ability to pay debts as and when they fall due, and if you can't consult the experts, as we've already spoken about, litigation can be an important part of ensuring you've got adequate cash flow. If you've got a supplier that owes you a couple of $100,000, then that can have a big impact. Being able to pursue that is important, but you also have to spend money to recover that. So, we certainly encourage people to consult with us earlier and give us all the information. We, as a lot of law firms do, certainly contemplate at-risk litigation on a no-win, no-fee basis if we're comfortable with the merits. There are now a lot of litigation funding companies around, and they deal with quantum of claim, everything from the very small to the very large. So there are a lot of options available that can take that litigation spend off your balance sheet, and that means you might be able to pursue litigation that otherwise you would have been very nervous about paying the legal bills to get to that end outcome. Or even if that means that you spend a little bit to recover that money, the business survives and then thrive from there.
Thanks, Alex. Now moving to options, the juicy part of the discussion here. Jason, are you able to go through with us some of the options that businesses have in sort of restructuring space?
Yes. So on the back of COVID, a new regime was introduced, the small business restructure, or SDR, and it's been a game changer for directors, and it certainly hasn't taken away from the other insolvencies either. It's just seems to have been in addition to it. The small business restructure is a game changer because it's the only regime of its kind where the directors remain in control through the whole process, and all they're doing is simply putting a proposal to their creditors to deal with their unsecured debt. These are typically driven by the ATO because the ATO is the largest creditor. In short, the process is you appoint a restructuring practitioner. You then have 4 weeks to put your plan to the creditors. The creditors then have 3 weeks to vote on that plan. All you need is 50% in value, more than 50% in value, to vote in favour of that plan, and that's accepted. The ATO has been actively pushing companies in this direction. They have a dedicated SDR team in the ATO. They and they were accepting plans at very low amounts initially, because they wanted to get these SBRs off the ground. So we've gone from basically no SBRs being done in 2022. I think it was about 70 to 3,000 last financial year, and the return that the ATO is expecting has increased along the way, and they've also incorporated what they call the public interest over the last 12 months, and that public interest is twofold. It's they look at the compliance history of the company, and whether or not there's been a number of defaulted payment arrangements or non-lodgements and whatnot. And they also look at the director loan accounts, whether the director has had their snout in the trough, you might say, and has avoided paying their creditors, in particular the ATO. The other restructuring regime, which has been around for quite a long time, is a voluntary administration through what's a deed of company arrangement, or a DOCA. The small business restructure is probably the light beer version of a voluntary administration and a DOCA, you might say. But in saying that, a voluntary administration isn't just for larger companies. Whilst it comes at a greater cost, it's definitely still an option available for small businesses if they don't fit within the parameters that are required for eligibility for a small business restructure.
And what are some of those criteria, Jason, for SBR that can be eluded?
So the three main ones are that you have to have unsecured debt of less than $1 million. Your all of your lodgements have to be up to date. They don't have to be paid, but they have to be up to date. And the big one is your superannuation has to be paid. And that's where a lot of companies stumble because they can't put the money together to deal with that superannuation up front. And so that can tend to lead companies down to that voluntary administration path, if they have the capacity to go down that path. the ATO, as I've said, is a big driver between any of these appointments. And what we're seeing at the moment is that in a small business restructure, you're likely to be successful at around about the 30 cents in the dollar and up from there. And if you're planning to pay over a period of time, you're not going to get a plan up with the ATO that's any greater than 18 or 20 months. That's whereas voluntary administration is a little bit different. You can still get DOCAs up at a lower level. The lucky number with the ATO seems to be around about that 15 cents in the dollar amount, and you can potentially get a plan up over a 2-year period. Yeah.
And I suppose another issue there in terms of the how many cents in the dollar is as a sole director lows, and how does that play into the fees and the replies?
Look, the ATO are pretty commercial about it. They understand that directors need to pay, and typically with small businesses, directors will just draw out of the business throughout the year, and when their accountants are doing their taxes, they'll convert it to income or a Div 7A loan. They want to look at the loan account and understand whether the director's been taking more than they should have, more than what's considered reasonable. An example of a failed SBR that I had, unbeknownst to me, because I was only reporting on the company's results over the last couple of years. This company had achieved a profit of $400,000 3 years prior to attempting the SBR. At the time, they owed the Australian Tax Office $200,000. The directors chose to take the whole $400,000 for themselves and not pay the ATO at all. And so the ATO considered that was in the public interest, that they shouldn't support the SBR. On the other side of the public interest is the compliance history. The one SBR that I've had fail had 47 failed payment rations.
Because in our previous discussions, you also talked about how there's a lot of work for our accountants to do ahead of these or a big way. To not limit options, of course, is to be up to date in terms of compliance. Because laying down the track, if there isn't compliance in terms of options and things, it really does limit options that are then available when you come and say to you, like Jason and Bradley Samovar.
Yes, Alistair.
So, but we had SBRs for about 5 years now.
They came out in 21.
Yes.
Okay.
And anecdotally, or David, have we done any observations about, are they later state of execution, or is there real success coming out of the, do they often, are they a stepping stone towards failure, or is there really some success coming through? You said
I don't think enough times has transpired to genuinely tell. I think most of the SBRs that have been put up have been successful in getting approved. I think the success rate is still up around the 80% mark, and there's not many that fail once they've been approved. The data that we don't have is going forward, have they ended up in some other form of insolvency once they've cleaned house through the SBR.
So we've talked obviously about these two options, which allow businesses to continue to trade. But Alex and Sam, are you able to talk a bit about what happens in liquidation and what exposure directors can expect in that scenario?
So it's really a twofold exposure for directors in that scenario where a company go to liquidation. Obviously, you've got liquidators that are duty bound to pursue claims, So they'll look for, have there been unreasonable director-related transactions that they can recover? Were the directors causing the company to be trading insolvent, and is there a claim there? And unfair preferences and things like that. So there's the claims with the liquidator or issue, but there's also the personal pressures that come back onto a director in a scenario where a company goes into liquidation. So before we talked about the ATO pursuing the DBNs, there's that exposure there. And there's also personal guarantees and other liabilities. So it's one thing to be dealing with the liquidation, but also the personal liability that is quite immediate after a liquidation commences. And I think you touched on having a lot of inquiries about winding up applications. I think with a lot of those inquiries we're seeing, there's directors that are also, they have proceedings that they don't even know about or had it dealt with in the county court for their tax debts. So it's really twofold, and there's a fair bit of pressure on directors in the current market, I would say.
The only thing I'd add to that, I suppose, is the director loan accounts we've spoken about. On the books, there is the director owes the company an amount of money. That is a real debt, and the liquidators will look at that as something they can recover. While that seems obvious to probably many in this room, sometimes directors just have their head in their sand and, that's just an accounting entry. My accountant told me that was all fine, sort of thing, and don't regard that as a real amount owing to the company. But liquidators absolutely do. And those claims are often pursued earlier and quicker than some of these other court transaction claims.
If we look at some of the types of proceedings that can come out of a company in distress, we touched upon this earlier. Maybe for Alex, how do oppression claims interact with insolvency?
One of the relief claims that come into the oppression proceeding is the winding up of a company. So, the obvious one is that can be an outcome that is sought, even though it is very rarely ordered, because the typical relief will be that one shareholder buy out the other. But there will usually be that threat of a winding up that hangs over the company if they can't either resolve it, or that is the most likely outcome. So that's probably the most obvious interaction between the two. And I suppose the other thing is that when there are oppression proceedings on, the day-to-day business of the company can sometimes fall to the wayside. So you are focused on the fight with your fellow business owner rather than maintaining and growing the business itself. So even a healthy company might face financial difficulties where they lose the focus on that day-to-day interaction of the business. So they've got to look at once in there.
Still with you, Alex. Given we have a number of insolvency practitioners in the room, what should they be thinking about in the current climate? What do you say, Lucifer?
I suppose that current climate or otherwise, that these sorts of avoidable transactions are still going to be bread and butter. That these are the ways in which liquidators pull in money for the benefit of the creditors that are left out of pocket. And with unfair preferences have faced some challenges in recent years with the Badenoch decision. So, that there aren't always things happening that change the state of the law, but they are still going to be really critical claims for the benefit of creditors. You touched on the insolvent trader claim where, Sam and I were acting for a director in the circumstance, and obviously sometimes you're on both sides of the fence, so you understand the differing pressures. But I think for unfair preferences, insolvent trading or any of these, it's get across the legal issues as soon as possible. To do your legal analysis, get your lawyer to do your legal analysis, really put together a pretty tight solvency assessment, and that's not just looking at the typical things that a company will have as financial difficulties, failure to pay ATO or payment arrangements not being complied with and those sorts of things. You do have to consider the commercial realities of what funding a company has available. Are there funds coming in from related entities, letters of comfort from parent entities, the director simply funding the ongoing losses of the company as we had in our case. So I think again, unfortunately, some of the truth is assess it sooner and do it in a comprehensive way. get proper advice and before you make decisions, and indeed change those assessments as you go along, because what is true day one of a liquidation or a proceed changes as new evidence comes to light, as new things are revealed in the cut and thrust of litigation. So don't be too fixed with a position day one. I'm going to win this case. It's the easiest case in the world. But be malleable and be adaptive to what happens as you go on in litigation.
Do we have any questions?
I just had one about sort of, you mentioned sort of directors sometimes having their head in the sand. That sort of denial that happens where a director just says, I just need a couple more months, I just need another quarter, I just need 6 more months, just need more time and things will sort of come right. Is that a common occurrence where the interest rate's too high, just waiting for it to come down, the fuel prices are too high? There's all these externalities rather than the director looking at the actual books and going, I'm actually in trouble?
You probably see that a little bit, Jace, with jobs that eventually come to you. So I'm going to Jason talk a bit more about that. But I mean, there's a million different reasons why a director delays. Some of it might just be that they perceive that they can trade their way through it. It's optimism. It's all things that are completely understandable, but limit your options moving forward. So and change the outcome that you get.
Unfortunately, the most common thing that we see is that directors are really good at doing what they do, but they're not good at running a business. That's probably the biggest thing for us. And so their eyes is so much on building their widgets as opposed to running their day-to-day business. And that's where the biggest issue comes from. But there certainly are a lot of pressures out there at the moment. As of 1 July last year, you're no longer able to claim a tax deduction for the interest on the ATO debt. So that's and the interest on the ATO debt is ratcheting up at close to 12% at the moment. So it's very, very difficult to claw that back if you let it get out of control.
To add to that, just to add to that, Guy, what we've seen, or by way of an example, obviously our team sees people often late in the mix, where they might already have DPNs when they have a wind-up theory listed in a very close time frame. And what we are saying, if I can be able, is, they might have had a couple of adjournments of the winding up. They thought, we'll try and sort it out ourselves, we'll go and seek finance, and then encounter some problems like in this scenario. Because of the situation with the ATO, they also found that their portal was locked. So they tried to obtain finance, which required the documents, their ATO documents, but they couldn't obtain them. Then they were sort of pushing up against that with another adjournment. And for the practitioners of reading go, as we get more adjournments, the ATO is going to be less willing, obviously, to do another adjournment or do that sort of breathing route. So as they then went along, they almost got to they come to the third adjournment, or they had a third adjournment going for their fourth. In a scenario where they came to us and I said, what have you got? What are you going to say to them for the basis of the adjournment? And I said, Nicole, I've got a conditional offer from it. Got finance. I said, it's not going to cut it. You look at it, conditional offer, there's too many spots where, unless you've been fed up with the money, you have to have a good basis to then, seek to adjourn or push off, get one out. You'll limit your options as you go along, become more on the into, and unfortunately, that's what we see. They get it. They might think you try to do it by ourselves. The cuts much more difficult. The answer all questions?
Yes. I've got a couple of questions. So in relation where there's like a related party loans, so shareholders providing a loan to the company, how are those typically treated in an insolvency scenario? Are there risks of then they converted to equity rather than debt, or challenge liquidated? And then the second question is, used in many successful cases where directors are able to negotiate out of provided personal guarantees. So, for example, in cases of bank loans or leases or other financing or commercial arrangements.
There will false border second.
Okay. In terms of related party loan, it really depends. It's a case by case basis, and it depends on the liquidation as to whether the company is in a position to pay a dividend to its creditors, and it's at that point where you will adjudicate on those loans, and you'll determine whether they're reasonable and appropriately verified so that you can distribute to them. You certainly do put a lot more scrutiny on related party creditors, but it really is a case by case basis.
And if it's genuine money that's been advanced and potentially on commercial terms and documented, then that will put the related party in a much better position than if it's not been documented. So I think that sort of addresses that. As to the second question, it very much depends on the party that is insisting on the personal guarantee. So certainly we see that there are opportunities to negotiate. If you're talking about the CBA, they're probably going to be less likely to vary what their typical terms are. Some landlords are going to be willing to remove the personal guarantee, but again, only if they've got some other form of comfort, whether by a back guarantee or some sort of similar security. And then if you're talking about other sort of commercial suppliers and the like, it very much depends on their attitude. So some that have potentially been merged before will be very, very insistent on personal guarantee. Some that are perhaps more comfortable with the commercial arrangement might be willing to let it go. So again, it's very much a case by case basis.
Yes, Bernard.
We're a director who's paying you money to the business, it's you, that doesn't enter the asset. What step do you take there? You declare that person bankrupt if the business was sold for as problem, or well, most directors we're finding now don't have assets and they know nothing, rules for obvious reasons. Where's that set?
So I mean, I suppose quite clearly a liquidator has an obligation to recover money for the benefit of the creditors. So they will always make an assessment of the commerciality and recoverability. So if a director doesn't have any assets by which they can satisfy a judgment or satisfy a debt, then that is a factor that they take into account. Sometimes it might be that the motivation for a director is that they have other directorships they don't want to lose, so you do hold that threat of bankruptcy over them to motivate them to find some money to compromise a claim. But realistically, you wouldn't be pushing the button to bankrupt a director unless you were very sure about some sort of end outcome that is money in the door.
And sort of things you might look to there is, was there some distress and, the directors then transferred the house to their partner. Liquidators also certainly look to that to see whether there's any merit to going down the bankruptcy path, because then there's recoverable transactions there for the bankruptcy trustee to look to.
A lot of the time, the liquidator is going to be unfunded as well. So you look to a creditor or a potential litigation funder to consider any action. And if you're unable to get some funding, you probably have to let your dogs lie.
Job how sometimes people often ask about the time frames before that. I'm a really huge thing to do detail around that related party unrelated preferences.
Everyone's looking at each other. My corporate law exam. I suppose there are different timeframes depending on the claims. Unfair preferences, you have 3 years from the date under the Act to pursue those claims. And obviously there's 6 months prior to that date that you can claw back payments that were preferential in nature. As you get, I suppose, more serious in how much they are perceived to have been to the company's detriment. So unfair loans have quite long. I think that might be a 10-year time frame. So there's differing time frames across the board. Preferences are as I said, probably the most common of them, and that's a 3-year period you've got to bring them, and 6 months looking back.
And so for director-related coverage transactions, it is a much longer time frame because we often have questions about, if there is a transfer, and people might be 1 year or 2 years ahead of the company's distress. If I transfer it, will it call back? Those kinds of time frames,
Therefore, yes, if it's unconditional.
Any other questions? I'd like to ask, in companies with partners or joint ventures, and we are the operating directors responsible for running of the company, how can directors best protect themselves? So, for example, in property development companies where the prices are high, but the returns are shared among the partners, what structures or safeguards are typically used to protect the operating director from the disproportionate personal risks?
I think it depends a little bit on what structure you're talking about when you're referring to partners. So, operating directors in that sort of scenario have the same obligations as any director. So, I suppose the risk mitigation for them is the same as it would be for any director. Be across the operations of the business and be across the finances, depending on the size of the development. Get appropriate advice from accountants. Make sure that you're really keeping an eye on that cash flow, which obviously in property developments is probably the critical issue. I hope that answers your question. Any other?
Probably just being structured in a way that you can best protect yourself. Pencil.
Yeah, so it's more like one partners coming in, and then you're the director of the company. So just a single directorship.
Yes, and I think that is what I said. The director is still the one that is on the book under the Corporations Act. You can't avoid that. So that director is the one that needs to be across all of the finances, get advice, all those things.
rather than the investors. That's what Nia's question for here. I think Rob in the question.
Yeah, no, three, Jason. First, I'm hoping it's being utilised period by the self-profession. Secondly, what's the status of discussion for tax presents blockers? And third, what's the threshold the AGO had set for a part-in arrangement?
Okay.
Last day there.
Holding DOCAs. Look, I haven't seen one for a while. I think that they're still around a little bit, but they're not that common anymore. In terms of the part 10s, I'm not across the percentage that the ATO is looking at for part 10s. I'm not a trustee, so that's not my wheelhouse.
But given the ATO are a body which doesn't tend to have flexibility in their policies, you would expect it to be relatively similar to the corporate sphere, I would expect. Yeah.
So about 30 cents then.
But we're not locking ourselves into any company.
Go lower,
Hence, unless you're going to be able to control the outcome, you're not going to put them up at the 5 to 10 cent range. If you've got a couple of liquidators within a group that have got large insolvent trading claims which outvote the ATO, that's something to look at. So in the absence of that, as Jason said, you're up at 30 cent and 50% strike rate.
Pre-packs.
Could you tell us what quick ad is or bad you?
Well, I'll add to that. Like in the concept of free pack, there's a deed of company arrangement. You actually put a proposal at the starting for, and then that's distributed and accept it basically. Away you go. That's a very simple term.
I think they're adopted in the UK.
Yeah.
Yes, that's. There was discussion about adopting in INSPA, but it's trying to let the discussions privately where it seems to disappear.
exactly right. Yeah, that definitely has disappeared. They do have that process in the UK, but it hasn't been adopted here. So it's really done on an informal basis. You all work with the practitioner and effectively look to come up with a plan before pushing the button on the appointment, that there isn't a genuine pre-pack process in Australia.
Any further questions? Otherwise, I might have one last one for each of you. What's your one takeaway for the group?
I mean, I'll kick it off. I think it's as much as it's easy for us to say to be proactive about things, because we see when it gets to the situation where the horse is already bolted a lot of the time. It's try and be as proactive as you can as a director. Seek advice from your lawyers and your accountants to best enable yourself to be able to do something about the situation you're in. Is quite optimist. It becomes too late to do what you could otherwise done at an earlier stage.
I think you ticked off a couple that were in my mind there, Sam, but I mean, maybe from a litigation front, I think I said it in the context of this insolvent trading case, but I think it's true of all litigation. Do your legal analysis before you bring a claim, possibly even before you bring a demand, and regularly review it. Things do move, things do change, new evidence comes to light. Potentially even new cases are released by judges that can have an impact on your prospects of succeeding. So in litigation, which spans 12 or 24 months, you need to be really looking at that strategy regularly, reconsidering it, and then obviously that changes your appetite to settle and those sorts of things.
Just adding on to that, my biggest thing is don't be afraid to ask for help. As a director, you can't do it all yourself. You need help. And if you're finding it difficult to pay your debts as and when they fall due, probably don't leave your accountant and lawyers off that list. Don't be a stranger to them, because they're the ones that are going to help you through this difficult stage.
Well, thanks very much to our panel for your insights, for your time, and thank you very much for our audience here in person and online. So if we could join a hand to thank our panelists.